How to deal with disagreement at mediation. Part of the series, Mediating with or Without Attorneys with Tye Bourdony. That is our topic for today.
Welcome to the Lawyers and Mediators International Show and Podcast by InstantMediations.com, where we discuss law and conflict resolution topics to educate both professionals and everyday people. Catch regular episodes on YouTube, the Instant Mediations app, and anywhere you get your podcasts. Just remember, nothing in these episodes constitutes legal advice, so be sure to talk to a lawyer, as cases are fact-dependent.
Hi everyone, Mac Pierre-Louis, attorney, mediator, and arbitrator working throughout Florida and Texas.
Natalia Łowska-Czajka, advocate, mediator, arbitrator from Warsaw, Poland.
And I'm Tye Bourdony, full-time professional mediator and primary mediation trainer in Orlando, Florida.
All right, welcome back everybody. So we are now dealing with how to deal with disagreement at mediation. And why is this topic coming up? Because people disagree. That's why they come to mediation, okay? And they need help to reach agreement and to enter into settlements. And so a good mediator is going to help people do that and move on with their lives and move on with their projects. But this is not always an easy thing. And so we wanted to have Tye speak a little bit about what are some of the best ways to deal with these major disagreements that come up between people. I mean, let's face it, if two people are divorcing, they may not like each other at that moment in time. They need some help, but they can run into brick walls and they need somebody to guide them.
Yeah.
Or maybe some contractual disputees need some help when they run into brick walls and they need somebody else to guide them through it. So, Tye, the floor is yours.
Thank you. I think in this instance, what I'm thinking of is specifically what you just said, and that is, you're dealing with the parties and you start talking about an issue, and like you said, you start to hit a wall. Your negotiations, which up to that point may have been going well, but for any one reason, the parties are having a hard time getting past a certain issue. And so I think the danger for a mediator is that you keep pushing, and because if you keep pushing too much, then the risk is that everything starts to fall apart. And so a mediator has to know when to push and when to kind of ease off. And so the nice thing about being a mediator is experience as a mediator makes you better, but also we bring to it all of our other experiences, right? So you bring your litigation experience with you as well, but you also bring your past experiences. For instance, I'm a professional artist, right? I could never make a lot of money, so my wife gave me a choice, so I went to law school. But as an artist, for instance, if you're painting or you're drawing or creating, whatever, sometimes you hit a wall. You don't know what your next move is. And so what we're taught as artists is step back from the piece, right? Get perspective on the piece. And so what does that mean in mediation? So for me in mediation, what that means is sometimes I'll tell the parties, okay, you know what? We've been trying to wrap our heads around this issue. And rather than going on, I'm thinking, why don't we leave it right here? Let's go on to this, and I'll pick something that's related to that issue, and then I'll draw their attention there, and then I will sometimes we'll then be able to come to agreement on that, and at an appropriate moment, I'll bring us back around, and then I'll show them, look, you did a great job. We've come to agreement, and now that we've agreed on this, does it change anything where this is concerned? Sometimes that works, or maybe it's time for a break. Literally, people might need to get up and move around. They might need to go to the restroom. They might need to get some fresh air. They might need to eat. Maybe it's lunchtime, right? People get hangry, as they say. And so I've also found that sometimes after folks have, because you're stuck and you're talking, your head is in this one place and you can't see some other option. Sometimes you need a little space. So one of those two a lot of times will work, but sometimes they don't. And then you have to, you know, then what? But that's worked for me often.
Other method that we can use is, as we say, Tye says, take a break. But sometimes you really need to even use the argument that you need to take a break so that they take a break and they stretch. Because this is all about it. Also about moving, about changing position, about making you breathe in a deeper way so that really your brain starts thinking another way so that you get new energy. Because really, some things that are discussed in mediation can make you gloomy, can make you feel very sad, even depressed, because actually you are going over something that already traumatized you, whether it is a failure in business, whether it is insolvency, whether it is family matter. So that can be really stressful and depressing. And usually we as people tend to follow our previous patterns. So if this issue in the past was being traumatizing to you, you will be doing the same. So it will be rather closing yourself down and thinking what I can do to really get it done as quickly as possible, or I'll just not say a word so that wait until it passes. No, the mediator's role is really to make the change in the environment as well. So this is one of the methods, one of the techniques. People need to move, breathe, so that they really get off the thing that they stuck themselves with and take this new perspective that Tye was describing.
Yes, and we've dealt with this topic before recently, actually, on a podcast episode with Julia Morelli, who was talking about how mediators themselves need to de-stress, right? And so a lot of the tips in that episode was to also not just apply to us, but apply to our clients and how we can help our clients relax a little bit, because that will go a long way towards helping people, have the right ideas percolate and do better. But on this topic about taking a break, I wanted to, I'm sure Tye, you may talk about this later on as well, but when it comes to recessing, even ever shortly, we got to remember that sometimes sleeping on an idea or just pushing away from the table and taking a break by turning your brain into something completely different, right? Watching your latest Netflix episode or doing something that's unrelated may actually help you think afresh. And that is so important. I know me, I do my best thinking in the mornings under the shower. But when that water starts falling on me, I just get all these great ideas, right? And can you imagine if I was a party to a mediation and then I have all these great ideas, I'll be ready to go and settle when I return. And so thank you for that, Tye. But if you have anything more to share about taking breaks and recessing, please, what was yours?
Yeah. So there's also a danger, right? And that is that sometimes that's what's needed. Let's be honest. For instance, sometimes you may get the sense as the mediator that someone needs to seek legal advice, right? They may say it. You may get the sense so then it's entirely appropriate. Or sometimes the parties are so stuck in a way that what's going to help them is if someone lets them know, because they haven't spoken to an attorney, right? And so I have oftentimes continued the mediation, and we've addressed they're going to speak to someone on this issue. They're going to research this issue, and then when they understand what because you've reality checked, but we can't give legal advice. Sometimes you can lead that horse to water, but it doesn't drink. And so they need to come back. And sometimes they come back and they have spoken, and sometimes they come back and they haven't, and we're still in the same place. But that's an instance when it is appropriate, or if the parties agree, yes, let's continue and come back another time. The problem is that if you're going to do that, are you going to come to agreement on everything you've already come to agreement on and kind of continue on this issue? Why do I say that? Because people get buyer's remorse. Then when they go home, then they think about everything that they came to agreement on, or they talk to their new significant other, or they talk to someone else, and they said, what? My cousin's sister's uncle's aunt didn't do that when they didn't have child support, or they didn't, and every case is quite specific. So there's also the danger that the good work that's been done gets undone, but there's nothing you can do about that sometimes. But you can try and have a partial, and in that partial agreement, right, continue and then come back on that issue. Sometimes they need legal advice. Sometimes they need perspective. Sometimes they need that proverbial shower, so to speak, in the morning. Or you can simply, sometimes it's appropriate to reserve on that issue. We can agree on everything that we can agree on, and what we don't agree on, we can reserve, and you can always go to court on just that one issue. Sometimes mediators love helping folks come to agreement. But again, as I often say, every mediation can't result in agreement. But it's also important, well, what can I give you? Because what we do here is that much less you have to do when you get in front of the judge. And if you do get an attorney, if you do have attorneys, that's when it gets expensive. When you litigate, well, at least you don't have to litigate all the issues. You can narrow them down. Sometimes that works. And then sometimes it's simply every mediation can't come to agreement. Sometimes the parties need to impasse, or their mediation needs to come to an end because they couldn't. But again, an impasse can be a good thing, right? That can be the thing that then helps the parties. Now we know we have to litigate, or now we know we have to address these issues. And sometimes the parties sometimes they have attorneys, and the attorneys can come to agreement between themselves, right? And or they can come back. It's case by case. Every case is different. And in that moment, the mediator has to ask themselves, okay, what do they need now? Well, in that moment, what do the parties need? And you can make every suggestion and give them every option that you can think of. Again, our experience as mediators helps us understand what do we do, moving forward. How do I help them now? There's no one scenario fits all, right? It's literally case by case.
Thank you. And back to this issue about taking a break. Sometimes you do take a break on purpose. For example, this purpose might be that you need to do some homework, meaning some things need to be done during the mediation, some more information gathered. That also gives you a new perspective. So a skillful mediator will give you a task which will be a part of your homework that maybe can change your perspective of things.
Yeah.
And the other thing is that sometimes a good method is to stop and to try, for example, in family law, that can be, and in between the mediation sessions, try in real life what you agreed upon. For example, in terms of custody. Sometimes people do pursue certain ideas that to us as lawyers, mediators, seems, let us say, weird. But we do not find a way for them to see how weird it is. Sometimes it is in terms of cost. Sometimes it is in terms of driving. Sometimes it is in terms of just additional effort. Things that can be done in a simpler and more efficient way. So why not to stop here and try your shared custody for 2 weeks or 3 weeks and see if really the model with Monday mother, Tuesday father, Wednesday mother, Thursday father is a good one, or isn't it better that from Monday to Wednesday there is the mother and then there is the father? So I'm just giving you an example out of my head because sometimes people do believe that they have the equal right and that equal rights need to be shared equally and then attributed in a way that really makes the life painful for them. But sometimes, of course, as long as it is not detrimental to the kids, try your solutions, see how it works, see if you really can do it the way you designed it, and then come back and have something more to say. This is also a good method. For example, all those, I'm sorry to say, in my experience was so far that it were rather women who were saying, no, this guy cannot take care of the kids, ever. So give it a try. See if it works. Let's move on with little steps. It might not be the entire weekend or the entire vacation time this time, but let it be a few hours. Let it be this very weekend. Do you want to have a say on that? Yes, we can agree what they will be doing. You can give all the provisions you want so that he follows. Let us come back and see.
Yeah. Good
Tye,
point.
if I could add to that before you continue, whenever I'm giving my opening statement to parties who are before me for mediation, I ahead of time tell them of all the possible outcomes we might be able to have today. Number one, we might have a full agreement because you guys agree on everything. Great. Number two, we might have a temporary agreement on everything to, like Natalia just said, see how things work. Number three, we might have a partial agreement, kind of what you alluded to earlier, Tye, when you talked about reserving some issues, right? So when I say partial settlement agreement, the parties will agree on what they can see eye to eye on, and what they disagree on, well, then they'll take those few issues to the judge. And judges love that because it kind of shortens down the list of issues and disputes they got to rule over. Okay, so full agreement, temporary agreement, partial agreement, and of course, we might recess. We might come back. Something that we talked about earlier, right? That you got to take a break. Maybe it's a week. Maybe it's 10 minutes. I don't know. And then finally, we might have no agreement. And with no agreement, well, we know what that means. It's an impasse. Tye, if you would like to continue.
Yeah, well said. Great points, both of you. And again, it's case by case, right? But absolutely, sometimes the point is sometimes the parties need a little time because there's any one of a number. Maybe there's still some discovery. Maybe any one of a number of things literally hasn't happened yet, and we need to wait for that to happen before we can, in a very common sense, way, be able to move forward, because the thing that we're unsure of now has or has not happened, and you'll know it's case by case, and that was very well said, Natalia, because for instance, there are sometimes instances when one of the parents hasn't seen a child in quite some time, or they've never seen that child, right? And so one of the parents is very worried about what that's going to look like, or there have been some other issues, and so we need to move forward with what we call like a step-up plan, right? Before regular time sharing will begin, or maybe it's long distance time sharing. Let's see how it goes, or can we have this happen, that happen, and the other thing happen, come back to mediation, and the parties will know best. Did it work? Were there issues? And sometimes that works really, really well as well. Great points. But again, in the moment, right, the mediator will see how things unfold, and that's when the mediator is going to think to themselves, what is going to be the best way for these parties to be able to move on to the next step? And sometimes they can, and sometimes a temporary agreement or a partial agreement, or coming back, right, in a logical amount of time, which will be apparent to the parties in that moment, right, is the answer. And you suggest it. Now that's the other thing, right? We can suggest, doesn't always work though. Now, does it? And I think it's also important for a mediator what I will do is, because I put different sections, right, in my agreement. And so if I have a temporary, I'm going to give it its own section, so that regardless of what happens, whether it's successful or not, every other section that agreement can still be binding, because if it's just one big agreement, then you might have to have another agreement, right? So, but temporary agreements, partial agreements, continuing, coming back at a different time, based on the circumstances that you find yourself in that moment, can be so beneficial. And the more experience as we have as mediators, and hopefully sometimes we have really good attorneys in the room as well. I don't care where a good idea comes from. And I'm never going to take credit. I'm always going to give it to, another individual, because you want to empower the parties. But sometimes it makes all the difference, right? And sometimes just common sense, and people will see it. And that's nice when the parties can, see through the emotion, and then that suggestion makes all the difference in the world. And then the parties come back, and I've seen often enough where it worked, right? So sometimes you can, sometimes you can't. Sometimes it's dangerous, sometimes it's appropriate. In that moment, the mediator, along with the parties, has to make that determination, and that's when our suggestions can be really, really helpful, right? Because you've seen it work here. You understand that this might be the issue that gets the parties to that next level. And that's when we have the S on our chest and the cape underneath our suits, right? And that's when it feels really good to be a mediator, when you can come up with that solution, even if it's a temporary solution, that can help the parties, get there. So well said. That's it. That's absolutely right.
Yeah, and Tye, as we're running out of time now, could you go ahead and give a final word on then when the impasse happens? Because sometimes the disagreement is permanent, right? Well, for the mediation session anyway.
Yeah.
And then can you just close out with telling us, okay, well, when do you decide that everything's been tried and impasse is reached?
Great question. I'm not the kind of mediator that, goes to impasse fast. On the contrary, my little rule of thumb is I'm going to ask in different ways 3 times, one way or another. But you'll know, right? You'll know, either you'll be told and you'll know just from listening. Your mediator's instinct, and I'm big on the mediator's instinct, will let you know, yeah, we're clearly we are at, they said it and they meant it. Or you have to, again, in that moment, you have to read the room and you're gauging. And if it is impasse, I will always be as positive as I possibly can be. And so one of my standard, lines is, look, I know we weren't able to come to agreement today, but you have a much better idea where you stand. And now the case is going to be able to move forward. And so even though it may not seem like it, I promise you, you're almost done. You're almost there. Now you can, and then whatever is most appropriate in that moment, right? You'll stress. But I want to, even in an impasse, even when there's no agreement, I'm still going to try and be as positive as I can be for the parties and show them the bright side rather than, there is no negative side, right? Yes, we're not at agreement, but now the case, right? Because while things are in mediation, the case stays right there. Now the case can move forward, right? And so now, do the parties need to get attorneys? The attorney is going to help you move best, or maybe you can come to agreement. For instance, in insurance cases, oftentimes we cannot come to agreement right then and there because, to Natalia's point, something hasn't happened that has to happen. But now the parties understand, okay, within this next amount of time, I'm going to get you this, you're going to get me that. And you understand from listening to them, we've set the stage. We have all the barriers, and so much miscommunication happens between parties before they get to mediation. And mediation is the best place where you can clear up all the miscommunication, and now they can move forward. Be positive, and impasse isn't a negative thing. Sometimes it's a good thing for the parties, case by case, of course.
Thank you so much. Thank you, everybody, for watching and listening. And that would be it from us today on how to deal with disagreements in mediation. And hope to see you in the next episode of our series. Signing off. Bye.